Welcome to Legal Lines. My name is Tom O'Shea, the host of this program that is brought to you by the York County Bar Foundation. We have a special program today. My guest is attorney Sandra Thompson, one of the candidates for the Court of Common Pleas of York County, Pennsylvania, with the general election coming up on November 7th. Tuesday, November 7th is the general election. Before I start speaking much with Sandra, let me explain what is going on right now. A number of candidates ran in the primaries back in May for the 3 open positions with the Court of Common Pleas of York County. The Court of Common Pleas is known as the trial court, which is the trial court level in York County. And there are four candidates now for the 3 spots.
That's correct.
And so in other words, the voters of York County will have the opportunity to vote for 3 of the 4 candidates, and 3 of them will be elected to take positions that starts in January.
That's correct.
The office would begin in January, and it is a 10-year term.
Yes.
Each of the 4 candidates have been offered the opportunity to appear on Legal Lines, and today I'm here with Sandra. So welcome, Sandra.
Thank you.
And before we get into substantive questions, just generally, tell us about yourself. How long have you been a lawyer? How long in York County, et cetera?
Well, I've been a lawyer since 1999. I've been practicing, even before that, went through law school, being a certified legal intern with the Office of Attorney General and also with the law school since 1998. So, and what else did you say about myself? I came originally from Philadelphia, came here in 1986 to attend York College. I basically stayed. York County became my home. I grew up from 18 years old to 49 years old right now. I grew up in York County. So from York College I went to law school in Widener University in Harrisburg. I worked at many local businesses. So I grown to know and love York County. And
you have been practicing law in York County your entire career?
Yes. I mean, my primary office is in York County. I started out at Mid-Penn Legal Services. Well, actually back then it was Central Pennsylvania Legal Services. Then it changed later to Mid-Penn Legal Services. I went through the York County Public Defender's Office. I was a district attorney in York County as well. Assistant District Attorney in York County. Again, I started before becoming an attorney and before going to law school, I was a probation officer and also worked in various, as I said, areas of the law by being a case manager for a juvenile group home. It was Mission Home Ministries. So yes, I think I know York County and
I
County
did not
very well.
know the probation officer background.
Yes,
I did not realize that.
Before I had always wanted to be an attorney. Growing up, I wanted to be an attorney. So, and through college, I got involved in certain things, and I was able to actually a brief segment. I became a single mother after college, and I applied to the county probation department back in, I think it was like 91, something like that. Somewhere around 90, I believe, I applied and didn't know, so I was still job searching. So I temporarily went home to Philadelphia, had my son, and then got called back to work at York County Probation. And so, but for in the last 31 years, but for about 6 months, I lived in York County.
And practiced in York County since, what, 1998?
Well, yes, as a student and also 1999 as a full-fledged attorney since then.
And can you tell us what types of cases you have handled as an attorney?
And that's what I think I started to say. My main office is in York County. I primarily practice in York County, but I also go up through Central Pennsylvania and Eastern Pennsylvania. So I practice in Dauphin County, Lebanon, Lancaster, Montgomery, Delaware County, and also Philadelphia counties. I also practice in state and federal court. So I'm admitted to the Middle District and the Eastern District federal courts of Pennsylvania. Also I'm admitted to the Third Circuit Court of Appeals and the U.S. Supreme Court. Haven't had to practice in those except for to file an appeal in the Third Circuit occasionally. But I really do almost everything besides the federal, which is civil rights cases. I do everything that, as you said, the local court, York County Court of Common Pleas, which is a trial court, everything that comes in front of it. I have been appointed by the courts and also done private appointments to guardianships in the orphans court. I have done wills. I've represented people who were either suing or sued by a nonprofit, which is again orphans court. I represent people in family law. I have represented divorces, custody support, PFAs. What other family law as well as termination of parental rights dependencies. I've represented from court appointed and private as well. Criminal. I explained how as a probation officer, public defender, prosecutor, and then for the last 14 years since 2003, that's when I opened up my own business. I've been doing defense. So in that's from traffic, robberies, aggravated assaults. I've prosecuted and defended people accused of rape as well, all types of offenses, as well as homicides. So the gamut. So that in civil, from slip and falls to traffic violations to car accidents. I've represented people, arbitrations, through other types of litigation.
So it sounds like you have an experience in all the types of things that a court of common pleas would deal with, that a judge in the court of common pleas would deal with.
Absolutely, and I think that's really what distinguishes me from the other candidates, that I have actually practiced, not just been an intern, but actually practiced law on a lot of different sides, so knowing different perspectives in almost every area that's going to be in the Court of Common Pleas.
And as far as it goes with the Court of Common Pleas, I don't know the exact breakdown, but I think much of the public would not realize that probably close to half the cases are family law related, and probably at least a third of the cases are criminal law.
Right,
and,
even if that's flip-flop, who knows?
But
right,
that's
exactly.
the bulk of the cases.
Yes.
There's also civil litigation,
Right,
but
exactly.
many of those get settled before they ever get to
That's
the
right,
the
to the
judge.
judge.
The judge can help get the settlement
That's
in place,
right.
but it really so the criminal background and the family law background would be the two areas that I would say would be the most helpful. I don't know if you agree with me on that.
Oh, no, absolutely. I mean, one of the first places we were normally assigned once being elected is family court. But I can actually go into family, I can go into criminal. So, wherever I'm needed, I'm already ready to go because I understand what it takes.
Let's talk a little bit about one of the questions that the Bar Association has asked me to ask candidates has to deal with the PFAs. You mentioned handling PFAs before,
Yes.
but for the public who, if you don't know, PFA stands for Protection from Abuse.
That's correct.
Now, it's a civil matter, it's a civil case. There could be an underlying crime where somebody needs a protection from
Right.
abuse order, but the process recently changed, and I want your opinions on how the PFA should be handled and what you as a judge would do with the PFA cases.
Well, even with PFAs, I started with that when I worked with Central Pennsylvania Legal Services, because they also work very hand in hand with victim rights advocates as well, and representing those who are filing for PFAs and who could not afford attorneys. So that's where I had my start with that, and then as a public defender and a prosecutor, the way we were involved with PFAs is if they were violated. And that's when it becomes, as you said, PFAs itself is civil, but then you get to indirect criminal contempts if they're violated, which are quasi-criminal. Because for each violation, you can get up to 6 months in jail. So again, I've had experience in those multitude of veins. As a private attorney, I've represented those who are seeking PFAs. I've represented those who PFAs were sought against them on both ways. So I do see each of the arguments and what makes it controversial. The beginning of this year, I believe, or end of last year, something like that, the YDR wrote an article about the number of, I think York County, it was said at the time, had denied the most, or one of the most, had one of the highest denials of temporary PFAs in the state. And the temporary PFAs are somebody coming to the court and making an accusation. And that's the person accused doesn't even know about the accusation at the time. And so they make the accusation, and based on the accusation, the judge or the court awards or denies a temporary PFA. And it's temporary only until you have the full-blown due process of court. The person is notified, he or she gets to come to court, and it's men as well as women who are defendants. They get to come to court, and it has to be proved. And some of the controversy about that is that ex parte, when the person comes and speaks to the court or speak to the judge alone, that's called ex parte. The other person doesn't have that chance to defend themselves at that time. So, and maybe it was a higher burden of proof that the judges put on it. And at this point, I think they are erring on the side of caution, but it's a right balance. Obviously, a right of the person who is being abused to be protected. On the other hand, it's the right of that person who is being accused to have due process, because the other thing that you quite often, in a person who is accused, based on the order, they may lose property. If they have weapons, whether it's like they're licensed to carry firearms, they do have firearms or knives or other things in their home, they will lose that. They have to, quite often, they have to give it up. Sometimes they can give it up to a family member or friend who will promise not to give them access. Sometimes the police take it. And sometimes the person is caused to leave their residence, and therefore they don't have a place to stay, and that affects employment if you don't have a place to stay as well. And it also could affect employment, just knowing police are here serving you with the PFA. It has a lot of implications for a person accused. So that is on the one side of looking at what happens to the person's due process rights if you are accused. But on the other side, then this is that balancing test of protecting the person who really needs protection. And that's the issue with PFAs, of trying to put force and weight of enforcement behind the paper so that the person can be protected.
And just to make it real simple for people who may not understand the PFA process, in many states we hear of these types of orders being known as a restraining order.
Right, exactly. Stay away.
Stay away.
Right.
You cannot contact this person for
Right.
any reason. Mm-hmm. And that will keep that person safe if they know that if they contact that person, you can call the police and the police will take that person away.
Right. And I mean, so that was one of the issues with the PFA and the change in the PFA. And I understand also part of the changes include that now there's the YWCA advocates who are the first point of contacts for people who are accused, and they can give them a lot of services, a lot of recommendations that county employees could not give. They would be prohibited from giving.
It used to be that when someone filed a PFA, there were county employees who assisted them, and that has now changed, that the YWCA offers a program, and the YWCA is assisting the people in filing the PFAs. And are you in favor of that?
Oh, sure, that's fine. I understand it saves a little money, and also, again, they're like the first responders. You know, the YWCA and that advocacy, women's advocacy groups against domestic violence and other type of violence, they are able to speak more about the resources and have probably resources more readily available to get the person into.
Sandra, I'm going to cut you off right here. We're running out of time for this segment, but we'll be back in a few minutes. Welcome back to Legal Lines. My guest today is attorney Sandra Thompson, a York County attorney who is running for the Court of Common Pleas of York County, Pennsylvania as a judge. Yes. There are four candidates running for 3 positions, and Sandra is one of the 4 candidates who won the primary and is now in the general election.
That's right.
So welcome back, Sandra. Now I'd like to talk a little bit about the criminal law aspect of being a judge. And one of the things the judge gets to do is sentence a defendant. And Pennsylvania has what's known as sentencing guidelines.
Right.
And a judge has some discretion with respect to what to do with the guidelines. Number one, how do you feel about the guidelines, and what criteria would you use to do something different than the guidelines?
Well, I think the guidelines are very good to have. I mean, part of the purpose of the guidelines was to make sure that a person who is accused of a crime would have about the same sentence in York County as Philadelphia or Pittsburgh, to make sure that it wouldn't go too high or wouldn't go too low without having to answer for it. So that's really the purpose of the guidelines, and that's a judge would have to answer questions as to why did you do this. So I do think that the guidelines are a very good thing, and I think it's also very important for the judges to be able to maintain sentencing discretion. So I think, so I understood when the Pennsylvania Supreme Court declared mandatory minimums unconstitutional, partly because it was just the district attorneys deciding facts and not the jury. And also it took a lot of discretion away from judges. If a person was charged with a minor crime, as the judge may have thought and may have the ability to rehabilitate with a lesser sentence or even not a jail sentence at all, the judge had no ability to do so, had no ability to conform a sentence for the individual person. And so I think that is very important for a judge to be able to do, and the guidelines allow for that. And whether you go up or whether you go down on the guidelines or outside the guidelines, again, as a judge, you will have to answer to a higher court for why you did it. So you should have reasons for it. And reasons may vary. It may vary on culpability. You know, how guilty were you in what you did? You know, maybe you did something with a group, but you were just on the sidelines and somebody in the group did more or did, you know, well, you did less. All of those things, those are factors that you weigh. Maybe you were involved in something, but you told on yourself right away. You cooperated with the Commonwealth and the police, so that may give you a more lenient sentence. Or you know, anything from a DUI, you got into counseling right away, there wasn't an accident, no one was harmed, and you're addressing your underlying issues. So all of those are things that judges can consider. And then the opposite end, you're someone who were the main aggressor, that you encourage all these people to get involved, and you harmed multiple people and you have no remorse, you're not showing it, did nothing to better yourself. So that may lead you to the higher end of sentencing. So those are the various things that are considered. And the underlying thing is, okay, do you have an opiate problem? Do you have a drinking problem? Are you a veteran with PTSD? Do you have mental health issues? So a judge should be able to hear all of those facts and see where all those factors should lay in judging the weight of a sentence.
Okay, thank you. One of the things that lawyers talk about a lot is the temperament of a judge and what's known as judicial temperament. Could you tell us about what you believe your judicial temperament would be, and give us some examples that would lead us to believe that was accurate?
Well, I like the American Bar Association's definition of a judicial temperament, and that's compassion, sensitivity, open-mindedness, decisiveness as well, and the commitment to being fair, to equal justice, and also the freedom from bias. That's how the American Bar Association defines judicial temperament. And I really think that that defines me. I think it defines me and the things that I do, from my community service to my advocacy as an attorney and also a community person. And I think that it defines me, and I go into court every day new. I don't, if the judge yelled at me the day before, the case before, I go into court every day new.
Now, you're not telling us a judge ever yelled at you, are you?
Okay. We'll keep those things secret. But
Okay.
but I'm saying I don't judge, and I try not to. Whether it's an attorney, whether I think the DA was unfair, an attorney was unfair, I try to take every case by that. You know what I mean? I mean, we're human beings, so you're always gonna, if somebody lied to you or manipulated you before, you're gonna always have that in the back of your mind, of course. But I'm going to still treat everybody with respect as I encounter you today and tomorrow. I try to do that in all things. So if I have to take a deep breath or whatever, I try to make sure that to temper my own personality sometimes as well. And that was a growth process. I had to mature to that to make sure to not really sometimes not take offense to everything and realize when we're in court, we do have a requirement to be civil to the other side, to the parties involved, witnesses, as well as the judge. And I think as judges, we have to realize that they also have a requirement to be the same. So I know that as an attorney, and being an advocate, I see and I know that an attorney's job is to try to change the judge's mind. Because I'm an advocate, I know that. So being a judge, I will understand that of why the attorney is continuing to make arguments. You know what I mean? If I think that I made my mind up and the attorney is trying to say, well, Judge, can you see this other side? And I think I will have understanding for that, but you also have to move the court along. I understand that as well. But I think the ability to be able to see both sides, the ability to give that opportunity to be heard is also part of that temperament. You're on the clock. Look, you're taking up too much of my time. I understand how those things are done, but I respect not to do it because we're there anyway to do a job.
Okay. And you touched on it very slightly, but I wanted to ask more about you said your community service and service to the profession. Can you tell us some background with respect to community service and how you believe that will influence you and help you as a judge?
Well, I'm a person who really ultimately believes to whom much is given, much is required. So I am active and always have been really, well, I'm going to say since I was 18 and my eyes have been open to the world. Been active in community service. So when I was in York College, I volunteered at various different things. I started with Crispus Attucks, tutoring students. So I got involved in that way, different things, advocacy issues from NAACP to other groups. I was on a bar association board until I termed out. The diversity coalitions. So the main thing is looking at what are some of the issues in society, York County, and how can I make a difference? How can I be an answer to it? I was a single parent, well, still, raised my kids as a single parent. They're 23 and 25 now, but understanding that to keep youth out of trouble, you have to keep them busy. So I volunteered with Girl Scouts, Boy Scouts, Junior Achievement, the York County Truancy Coalition, York County Domestic Violence Task Force. I'm on a York Opiate Collaborative right now. So I'm on a board cornerstone to address the issues of homeless youth in the city. So I have engaged a lot of Stop the Violence initiatives, dealing with education of people before in my law practice because of the fact of seeing both sides as a prosecutor and sides of seeing defendants who will find themselves in the criminal law and subjected to that, and hearing parents who have tried to stop them from being. I got involved with the York City Police. I did a gun buyback program. I'm not against Second Amendment. I'm licensed myself, but that was just a measure of people who were trying to sell their weapons on the street to make a quick dollar, and then the young people who couldn't really be licensed to carry a firearm, willing to take that firearm and getting themselves in trouble. So it's just trying to be the go-between of this is a safe way, this is a legal way. If you wanted to get rid of your weapons, let's do that safely, because I'm all about maintaining a weapon and with safety. and education. So it's just dealing with the issues of the community, whatever it may be, helping people to get education, quality education.
Okay. Do you believe any reforms are needed to the judicial system? And if so, what would they be?
The biggest issue is access to the courts. As far as being an attorney and the things that I hear is the access. I know there have been great strides with the self-help center that's now on the 4th floor, so people can go there and get help of how to file a case on their own. Mid-Penn Legal Services does have also self-help trainings with the custody workshops and other things like that. But the access to the courts are those who fall in a gap. They may not qualify for Mid-Penn Legal Services, and they may not even be able to afford representation for the, I believe, not the pro bono, but it's a mid-level now that they have. It's like a low-cost program that the Bar Association has. But believe it or not, people still can't afford it.
I think it's modest means.
Maybe that, yes, right. So there's still people who need access to the court who fall in those gaps. And so that's something we have to continue to make sure that they can access the court. And one of the things that I've said is, even if you can't afford an attorney, the best attorney or an attorney at all, if you have a fair judge, then you're still going to get due process. You're still going to get a fair hearing and the opportunity to be heard.
That's one of my other questions
Right.
then, because how does you, as a judge, deal with the pro se litigant? By the way,
Right.
pro se means a person appearing before the court without an attorney.
Right. Well, I mean, I've seen it done, and I've seen it done very well by the courts. And the main thing is, you can guide them to places, and you should recommend them, such as the self-help. There's books, there's standard PA practice that sometimes help you walk you through it. I think some of that is and the other thing is, there are certain questions, like for instance, custody. Custody has, as you know, the 16 factors. And the judge is required to make sure that they have an understanding of how those 16 factors benefit the child, the best interest of the child. And so even if the person is both parties sometimes in a custody action or in the front of the court representing themselves, regardless, the judge has that duty to make sure that the evidence comes out so he or she has the ability to make that proper decision.
So a judge has to balance the fact that I can't represent you as
Right,
a
exactly.
party, but at the same time, I need for you to get out all of those 16 factors, for
Absolutely.
example.
So if the judge has to ask questions of a witness or ask questions of the parties because the parties aren't effectively doing it, then that's what the judge has to do, because the judge has to have a reason for his or her
Now,
decision.
Sandra, I don't want to cut you off,
No,
but
no,
we
no.
have about 30 seconds left. Could you tell us briefly why you believe you should become one of York County's next judges?
I'm going to show you my card as well a little bit. Hopefully people can zoom into it. But this also tells you a little bit about it, that, from my experience, from my legal and my life and my community experiences, I have learned to be fair yet firm and insightful. The insightfulness comes from my life, the lives of the people that I've represented, and as well as experience from the court. And to be a fair judge, you should have that insightfulness.
Well, thank you. I have to cut you off right now. This is Legal Lines.
Okay.